Your Honor, when you turn on the video and it's between,
But remember, this is probable cause. I don't get access to all that stuff.
I understand that, Your Honor, but when the officer basically decided that he's going to arrest her, basically he puts her in the vehicle, and before any investigation is done, he says, I'm charging her.
Respond. Your Honor. Okay, sorry. Mr. Newling, hey.
How are you, sir?
Good, man.
Fine.
Two back-to-back probable cause challenges, one judge and attorneys determined to poke holes in police work. But will Judge Fler bend under pressure or stand firm? Buckle up. This ride's about to twist.
I see it here. Okay. Okay.
Yes, Judge. So for Mr. Rendes, on October 8th, 2023, officers were dispatched to a crash on West Sam Houston Parkway, and upon arrival, the officers observed the defendant's truck stopped in a moving lane of traffic with a flat tire and fender damage. The defendant was standing outside the car, but admitted to driving and drinking that evening. The officer observed the defendant to have bloodshot eyes, glossy eyes, and a moderate odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 2 out of 8, one leg stand 0 out of 4. The defendant consented to giving a breath sample, and the results were .074 and .073.
And Your Honor, regarding that dispatch to a crash, we did request an accident report and then found out that this was just about the defendant's tire having been popped. There wasn't an accident report that we did in fact find. It was a flat tire and front fender damage, however.
That's where we are. Defendant had told me that as he was driving on the parkway, he had a pop on his tire in the middle of the road. So at that time, he has to stop. I was trying to wait for the subsequent.
Chess Chast Blackburn. Regarding probable cause, I have issues with probable cause in this case, Your Honor.
Okay, let's do it. Alex, you ready?
So officers were conducting an unrelated fatal accident investigation when they observed the defendant's vehicle traveling at a high rate of speed towards the blocked portion of the roadway. The officers saw the defendant disregard a barricade and were able to successfully get the defendant to stop by shouting verbal commands and utilizing their flashlights. Upon contact, the officers observed a moderate odor of an alcoholic beverage, glassy eyes, watery bloodshot eyes, and slurred speech. The defendant admitted to having 3 drinks at a nearby bar and was temporarily detained. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and run 4 out of 8, one leg stand 2 out of 4. DICs were read and the defendant consented to breath. The results were .086 and .084.
Your Honor, when you turn on the video and it's between,
But remember, this is probable cause. I don't get access to all that stuff.
I understand that, Your Honor, but when the officer basically decided that he's going to arrest her, basically he puts her in the vehicle, and before any investigation is done, he says, I'm charging her. This is prior to basically any field sobriety tests being done. She didn't have any slurred speech, Your Honor. No bloodshot red eyes at all. He said all the buzzwords to trigger probable cause. I'm asking the court to watch the video for 5 minutes, Your Honor.
No. That's in for a suppression hearing. This is a mere probable cause, right? So because I have to give them the ability to respond to your arguments. We can't do that in a probable cause. Like, you know what I mean? So if you're saying it is as it is, see if they'll do a dispositive motion to suppress, where if you win, they'll dismiss, but if you lose, you got to plead, right? Otherwise, we can set it. But, when you start getting into the video, when you start getting into the minutia of, well, she really didn't have this, she really didn't have that, I have to give them the ability to respond to that. I can't just rule on it, whether, there was an actual traffic infraction, that's like probable cause or not, right? But when you start getting into the actual details, everything, I mean, that's for, either a suppression or for trial.
That's very
So ask them if they're good for, dispositive. That's something that you want to do. Let me see. It's only 60 days old, so you've got some time, I'm happy to do however, go forward with however you want to go forward, but For probable cause purposes, you're getting into argument, right? And I can't give them, I have to give them the ability to
Notice what just happened. The defense tried to pull video evidence into a probable cause hearing. Smart move? Maybe. But the judge draws the line. Video challenges belong at suppression hearings. What do you think? Fair or rigid?
respond. You know, okay, sorry. Mr. Newley, hey,
How are you, sir?
no, man.
Fine. I'm trying to revisit a PC for Mr. Rendes Atimio.
Okay.
You want the cost number, Judge?
It's on docket today, right?
Yes, Judge.
I see it here. Okay. Okay,
Yes, Judge. So for Mr. Rendes, on October 8th, 2023, officers were dispatched to a crash on West Sam Houston Parkway, and upon arrival, the officers observed the defendant's truck stopped in a moving lane of traffic with a flat tire and fender damage. The defendant was standing outside the car, but admitted to driving and drinking that evening. The officer observed the defendant to have bloodshot eyes, glossy eyes, and a moderate odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 2 out of 8, one leg stand 0 out of 4. The defendant consented to giving a breath sample, and the results were .074 and .073.
And Your Honor, regarding that dispatch to a crash, we did request an accident report and then found out that this was just about the defendant's tire having been popped. There wasn't an accident report that we did in fact
Thank
find.
you.
It was a
Okay.
flat tire and front fender damage, however.
That's where we are, Judge. Defendant had told me that as he was driving on the parkway, he had a pop on his tire in the middle of the road. So at that time, he has to stop. I was trying to wait for the subsequent traffic to clear, and that is all. There was no accident, just like
I know, but that's not that's not definitive, right? So what happens is a cop comes to investigate, right? And I guess that's when he sees. So, there are several theories in the law, like community caretaking, right?
Yes.
Where an officer is just going to make sure that someone is okay, and when they arrive, they start seeing indicia of intoxication, and then they can, I guess, you know,
Yes, Judge.
and the blood is out now, and it's not up to the legal limit of .08 two times. So even if we find the average, we're still below par.
Right.
And that's where we are now. So when I spoke to her, she said, well, unless if the judge will not find a piece, but she's okay.
yeah, I mean, I think, remember, this is just to go forward. Whether they're guilty beyond a reasonable doubt, that's something completely different. But, you know, taken as a totality by himself, it's not an accident, but the cop can, you know, come up and just look to see, hey, is everything okay? And then that's when he sees.
If you look at the totality of the circumstance, Judge, and anybody using the road, it could be a judge, it could be me, and you have a pop of your tire in the middle of the road, it's expected that you stop. And you have to wait to get clearance to park your car properly. So if somebody may have thought it was an accident, like they had assumed before, in this case, the state said within themselves it wasn't an accident.
There's nothing wrong with an officer just coming and riding up to a scene to assist someone. I don't think that there's anything wrong with that. And then when he goes to assist the person, he realizes, hey, there might be something else that's afoot here. And then that's when he begins the investigation, right? It's enough for PC, but it may not be enough for reasonable doubt, you know? If there's a .07, I don't know what happens with the field sobriety test. Have him eval it for trial, you know? And perhaps and they'll see, let's set it.
Yes, Judge.
Let me see how old this is, Rendes. Oh my God, it's 477 days old. Oof.
Because they're waiting for the blood.
It took 2 years though. Yeah, he was gone for a year. So let's do this. let's set it for a week. Will you eval it for trial to see, is this something that you can actually make? I mean, you know?
Yes, Judge, we'll eval it.
So let's set it for 1 week. Let me have them eval it. Can they make the case? You know, it's not about just convicting every single person. It's about doing justice, right? So let's see. There is enough just for probable cause, but let's see what they.
So here's the takeaway. Probable cause isn't guilt. It's just enough to keep the case alive. Judge Fler makes that crystal clear. What's your take on this ruling? Drop a comment, hit like, and subscribe for more dramatic courtroom moments.
Say about it. Okay?
Thank you, Judge.
Okay, thanks, Mr. Miller.